On News 13, the latest breaking news, county by county coverage, plus weather on the ones. This is your midday news weather now.
The U.S. Supreme Court wrapped up its most recent term, and at the same time, court watchers are speculating about a possible retirement for the court's most senior member, Justice Anthony Kennedy. With us to talk about that possibility is Barry School of Law Professor Terri Day. Terri, thanks so much for joining us today. So if Justice Kennedy retires, what will the impact be on the court?
Well, it'll be huge, and that's why it's big news about his possible retirement. Justice Kennedy was appointed by a Republican president, so people tend to label whether a justice is conservative or liberal based on whether they were appointed by a Republican president or a Democratic president. But Justice Kennedy is a moderate conservative, and he's liberal on social issues. And so, you know, he was the forerunner on the Supreme Court and the one who, you know, the swing vote in terms of a lot of the what people consider liberal issues like same-sex marriage, abortion, death penalty, those kinds of cases.
So if President Trump's first nominee did not get a full court opposition from Democrats in the Senate, would it be different in this case, and why would it be different?
I think it'll be a lot different because Justice Gorsuch was very much in the same vein in terms of judicial philosophy, constitutional decision-making as Justice Scalia was. So, you know, Justice Gorsuch basically replaced Justice Scalia, and they were very like-minded in terms of their judicial philosophy and constitutional interpretation. So if President Trump would nominate the next the next justice to replace Justice Kennedy, who is the swing vote and often votes with the liberals, so-called liberals on the court, on social issues, President Trump is going to appoint someone very much in the vein of Justice Gorsuch. And it really turns on the way that Justice Gorsuch versus Justice Kennedy, or any replacement for Justice Kennedy, would interpret the Constitution.
And it would really change the composition of this court.
Yes. And so, for instance, to give you an example, Justice Gorsuch, like Justice Scalia and Alito and Thomas, Justice Roberts most of the time, but take a very original view of the Constitution, especially when it comes to individual liberties, such as same-sex marriage, right to abortion, those kinds of things. So anyway, Justice Gorsuch and Justice Scalia said, if it's not in the Constitution, if it's not written in there, then the Constitution doesn't protect it. Whereas Justice Kennedy and more of the liberal justices on the Supreme Court say that no, that the rights have to be implied, that the framers created a framework of principles of dignity and autonomy and individualism, but how those are interpreted have to be in terms of modern day, you know, realities.
So in the vein of it's a living, breathing.
Yes, exactly. So while our U.S. Supreme Court says nothing about a right of privacy, now many state constitutions do, but the U.S. Supreme Constitution does not. The rights that are protected under the 14th Amendment and 5th Amendment due process in terms of a liberty interest or a right of privacy that's implied to be free from government intrusion into very personal decisions. usually surrounding the family, who to marry, whether to use contraceptives, you know, who makes up the core of the nuclear family. Those things, in terms of those justices who recognize an implied right of privacy, recognize that as being protected under the Due Process Clause.
Thank you so much, Professor.
You're welcome. Thank you.